Section 4E includes the administrative provisions and other remedies under the Uniform Securities Act. If the administrator thinks that a person has engaged in or is about to engage in an activity that violates state securities law, the administrator may issue a cease and desist order. Stop doing that without a prior hearing. The administrator may bring action against a person in an appropriate court. The only reason why the administrator would want to bring action against a person in an appropriate court would be to prosecute someone for a willful violation of the Uniform Securities Act. The administrator has the power to investigate persons inside this state and outside of this state, in public or in private. The administrator has the authority to ask people to answer questions in writing under oath. The administrator has the power to subpoena witnesses. The administrator may also petition the appropriate court to order the person to appear and produce requested evidence. The administrator may appoint a conservator over a defendant's assets. You do have the right, however, to appeal any decision made by the state securities administrator. You do have the ability to appeal. There's some numbers within this section that we need to memorize. So over the years, we made up a mantra. So tonight when you're trying to go to sleep and you can't go to sleep, you're going to say this to yourself over and over and over. It will help. It will make sense at some point, I promise. It goes like this. 5, 3, 5, 3, 2, R, 30. 5, 3, 5, 3, 2, R, 30. So the first three numbers are for criminal violations of the Act. Criminal violations. So this is a willful violation of the Uniform Securities Act. So 535. You may be fined $5,000 and or sentenced to 3 years in jail. These are the penalties if you are found guilty of a willful violation of the Act. 5-3. The last 5 is 5 years. This is the statute of limitations to be found guilty of a willful violation of the Act. 535. So it is a bigger fine and smaller time. Kind of rhymes. It helps me remember. Because trust me, you're going to get into the test and then they're going to flop those two around and your brain is full and you're nervous. So it's bigger fine, smaller time. $5,000 fine and or 3 years in jail. 5 years is the statute of limitations to be found guilty of a criminal violation of the Act. So then we go on to the 3-2. So 5, 3, 5, 3, 2. So these were criminal. This has to do with civil liabilities. Sometimes you violate the Act, but you didn't know that you were violating the Act. If the customer realizes that you have violated the Uniform Securities Act, your customer may sue you. So you need to know what they can sue you to recover. What they paid for the security, what was paid. Plus attorney's fees and court costs, because they're bringing forth a lawsuit against you. Attorney's fees and court costs. Plus any interest as set by the administrator. Interest as set by the state securities administrator. So these are positive amounts, these first three things. minus any income received. Minus any income received. So if while your customer owned the security that was sold to them in violation of state securities laws, they had interest income or dividend income, or they had a gain of any type, minus that. So this is what your customer may sue you to recover. This is not eligible for what we call treble fees, not treble fees. Treble fees are triple damages. I'm not a lawyer, but there are certain things that are eligible for triple damages. For example, if you violate insider trading laws, you will be fined 3 times, so 300% of the profits or losses that you avoided. So that's something that's eligible for triple damages. This, however, is not. So a violation of the Uniform Securities Act is not eligible for treble fees. How long does your client have to sue you? So that's what the 3-2 is. So we have 5-3-5 criminal, 3-2. Your customer has 3 years from the date of sale to bring forth the lawsuit against you, or 2 years after discovery of the violation. Whichever occurs first. So I have to explain this. Whichever occurs first. So I sold you something today, and you realize tomorrow that it was in violation of the act. So what happens is this 2 years starts to tick down. So the minute that a customer realizes that something was in violation of the act, that's when the 2 years starts to count. However, if I sold you something in violation of the act today, and 2.5 years have gone by, and that's when you realize that it was in violation of the act, you can still bring forth a lawsuit against me because you have 3 years. So it's 3 years from the date of sale, or 2 years after discovery of the violation, whichever occurs first. So that's how long they have to bring forth a civil lawsuit against you to recover what they paid for the security, attorney's fees and court costs, interest as set by the administrator, minus any income received. But let's say you sold something today, 5-3-5, those are criminal. 3-2, we learned those. 3-2. Let's say you sold a security today and you realized tomorrow that it was in violation of the act. Oh my gosh, of course you didn't mean to do that. You want to make it go away. You're going to send your client a letter and you're going to offer them what is called the right of rescission. RR stands for the right of rescission. You're basically going to rescind the contract. You're going to pay the customer what they paid for the security, plus interest is set by the administrator, minus any income that they received. The only thing that you're not going to do that they got when they brought forth a lawsuit against you was the attorney's fees and court costs. So you send this letter, you explain you didn't mean to do the wrong thing here. I'm offering to make it right, basically, is what this letter is. Your customer has 30 days to read this letter and take you up on the right of rescission. After 30 days, they cannot sue you. So if you send this to your customer offering the right of rescission, and it turns out they're vacationing in Europe and nobody's reading their mail, and when they do get back a couple months from now, when they finally read their mail, they can't sue you. Plus, they lost their right to exercise the right of rescission. So it's a 30-day offer. And after that, they cannot sue you. So that's what the 3-2 stands for. So 5-3-5-3-2-RR-30. So all of these are for civil liabilities. So the 3-2 says how long they can bring forth a lawsuit against you. You offer the right of rescission to avoid a lawsuit. So you try to make sure they're not going to sue you. Obviously, if you had known it was against the law, you would have never done it in the first place. So you're trying to do the right thing by offering the right of rescission. So I expect at least 4 questions will come from that mantra that you will say to yourself over and over and over. 53532 RR 30. Of course, the right of rescission does not apply to willful violations of the Act, which may be criminal. The administrator may refer evidence concerning willful violations to the state attorney general or district attorney, who may bring the appropriate criminal proceedings. The scope of the Act. More than one state's act may apply. We have a funny little acronym that helps us remember how this works. It goes like this, DOA. If an offer is directed to a state, then that state's act would apply. If an offer is originating in a state, then that state's act will apply. If an offer is accepted in a state, then that state's act will apply. So you're sitting at your desk, the phone rings, you're in Texas, and a customer calls you up from Idaho and offers to purchase securities. Can you proceed with the transaction? Only if you're registered in Idaho and your broker-dealer is as well. So if any portion of the transaction occurs in a state, you will be required to be registered in that state. If you and this client decide to meet in Vegas to finalize the transaction, then you're going to need to be registered in Nevada as an agent as well. So DOA, that helps us remember. The only exception to this is originating states for advertisements. If it's a radio ad or a TV ad, advertisements are regulated by the originating state only. The ad might be in the newspaper, and the newspaper might get on the plane in LA, and it might land in Florida by the end of the day. You have no idea where it's going to go. So advertisements are regulated by their originating state only, with one exception, and that's any time a publication has more than 2/3 of its circulation outside of its state of publication. If that's the case for something like, let's say, USA Today, no state act applies. So does that mean the ads in there, those can be fraudulent? There's no rules for those ads? No, of course not. If no state's act applies, then federal law would apply to that advertisement. General provisions of the Act. You would never want to file anything with the administrator that is false or misleading. Of course not. The Act empowers the administrator to make administrative rules as necessary. So the administrator governs using orders, we talked about cease and desist orders, rules, and enforces the laws. So the administrator has the power to make a rule as necessary to protect the public. There is this attempt to have uniformity across state lines. All rules of the administrator must be published and are available from the Secretary of State. Documents are considered filed when they are received by the administrator. The administrator is required to keep a record of all of the registered persons within the state, all of the suspensions and revocation orders that have been issued. All of that you can look it up online these days. That concludes our discussion for administrative provisions and other remedies under the Uniform Securities Act. Now it's your turn to go practice the questions.